we are bringing you a very special episode devoted to remembering Justice David Souter, who passed away this past May. And for this conversation, we are super fortunate to be joined by Professors Larsen and Erin Delaney. Allie is the Taylor Reveley Research Professor and Alfred Wilson and Mary I.W. Lee Professor of Law, and the Director of the Institute of the Bill of Rights Law at William and Mary. We are big fans of her work on amicus briefs and on appellate court fact-finding, among other things. She clerked for Justice David Souter during the 2005 term. And Erin is the Leverhulme Professor of Comparative Constitutional Law and the inaugural Director of the Global Center for Democratic Constitutionalism at the University College London. Before that, she was on the faculty of Northwestern, where she retains an affiliation, and she is a singular expert on comparative constitutional law. She clerked for Justice Souter during the 2008 term. Allie, Erin, welcome to Strict Scrutiny.
Thank you so much for having us.
Thank you.
So let's begin by discussing your experiences clerking for Justice Souter. What do the two of you most remember about the justice as a boss, as a person, or as a jurist? Erin, maybe let's start with you.
Thank you. So many wonderful things about the justice. I think probably his humanity and his personhood, right? And I see Allie nodding already, getting to know him as a person was a remarkable opportunity, but part of that was his very intentionality about the sense that when he was hiring clerks, he was hiring people that he wanted to be his friends. And that is a tremendous honor to think about, that you are not only being chosen for, having had good grades, but really for the idea that you would be an interlocutor over time and a friend of this really remarkable man.
Allie, how about you?
So I kind of, when I first met him, I expected to meet someone weird and quirky because he had that reputation.
Weird has a specific connotation these days.
The old weird.
Yeah, the old weird.
The old weird. Old school weird. Like somebody not very socially adept. That's what I thought I was going to meet, but that's so not true. I mean, he was very good in a living room. He was very good making people feel comfortable around him. He had a great way of telling jokes. And I would remember my mom, when she met him, she said, "Oh, David, it's so nice to meet you." And I was mortified that my mom would call him David. And he said, "Allison, that's my name." And it just that's how he thought of himself, was as a David, not a justice.
I'm reminded of Josh Chaffetz had a great piece in the Times last year that said something like a Supreme Court a person's first name is not justice or whatever.
Right.
Just like there is something deliberately, sort of mystifying about our attachment to that term. And I think I didn't realize that he did not insist on always being referred to as justice. So that is great. So Allie, you wrote a tribute to Justice Souter on a SCOTUS blog, which ran, a bunch of tributes after he passed away. And yours was titled "The Heartbeat of the Law is Human Connection." And you reflected in it on some of the greatest lessons the justice taught you. So I'm going to quote from it: "The value of caring for others, the wisdom in slowing down to get the law right, and the incredible power when those two forces are combined." So can you elaborate a little bit about, kind of how those lessons were imparted? And was there anything particularly memorable in your time with the justice and how he approached cases? Or, you already talked a little bit about how he interacted with the people around him that kind of exemplified those qualities?
Yes, absolutely. So, I mean, he really felt like what he was doing as a judge, affected the lives of other human beings. And that meant a great responsibility that he had to use his, I think he said, the power of his mind and the power of his heart to get the rulings right. And that was really influential on me as a young lawyer. I mean, I remember one day we had a emergency application in a death penalty case, and I was super overwhelmed by it, just the high stakes and the last minute nature of it. And I remember him saying, even if he didn't agree with me on the merits, he was like, "It's so important for you to remind me about the humanity here, because that's the most important thing we do." And I think that's a really important legacy.
So tributes to Justice Souter invariably note his modest lifestyle and unassuming daily routine. During his 19 years on the court, he famously didn't own a cell phone, rarely used email, wrote with a fountain pen, and normally ate an apple, core and all, and a cup of yogurt for lunch. Then when he stepped down in 2009 at the relatively young SCOTUS age of 69, it was generally accepted that a key motivation was his desire to return to his home and his books back in his beloved New Hampshire. Are there any particularly funny or notable idiosyncrasies that you remember from your time with the justice?
Well, I have one. So I had the pleasure of clerking with him in his last year on the court. And so you talked about his sort of modesty and everything else. There were a few moments that year where he tried things for the first time. So one was the first time apparently he had a Sprite at the
He's really living it up
holiday.
that final year.
It was really exciting. At the
This is
party,
David
the Supreme
Souter's take
Court.
on YOLO, by the way.
Yeah, really. And we found out this because my cousins were my guests to that holiday party. You were able to have family. So my cousin and her daughter, who was about 9 months, and her name was Sophie, just dove her hand into the justice's Sprite. And he said, well, it was the first one I'd had and I wasn't really enjoying it that much anyway. So he was living on the edge. But the second point to his austerity, he went to resign, went to the White House and went to speak with the president to step down. And he wore the same suit that he wore the day that he was interviewed. And he came in and said, look at it, it still fits and it's perfectly good. Plenty of wear left in it 19 years later.
As someone who rarely updates their wardrobe, I really feel so seen by that anecdote. Let me ask one question about the suit. Was it a three-piece suit? Because he almost invariably wore a three-piece suit. And he rocked a three-piece like few others could. He looked so good in his three pieces.
Yeah. And he refused to wear a coat.
Oh, I did not know.
Famously, never would wear an overcoat.
It's that New Hampshire kind of tough exterior. You don't need one in D.C. Did he not wear one even at home in New Hampshire? I wonder. Never. Amazing. Okay, so that's sort of some of the kind of personal dimensions of Justice Souter. Wanted to pivot now to ask about how you would characterize or how you think about Justice Souter's overall judicial philosophy. So maybe, Allie, you want to start with you?
I think of him as like a small c conservative, as in somebody who was very careful, very deliberate, very respectful of precedent, very aware of his own capacity to make a mistake. Like, he had a lot of judicial humility. I do think it's important, and others have said this, like Charles Barzin at UVA, that doesn't mean he thought that all of the law was like clear-cut and objective like math. He rejected that. He in particular believed that as the facts changed, societal values changed, our interpretation of the Constitution had to change too. So that's not what I mean by conservative. But he was very much a common law judge, a one case at a time judge. He didn't care about making big ripples or bold statements or sound bites. He was
writing for all of history.
Right. He wasn't doing that. Like, he wasn't doing that at all. He was more
What's
concerned.
the opposite of Neil Gorsuch? Okay, that's him. Yeah.
I think he was more concerned with, like, I don't know, carrying the torch of like judicial independence through his chapter of history and not messing it up.
I could not agree more. I think Allie said it very succinctly. As I was thinking about this question, all that came into my mind was humility. It kept coming in, epistemic humility, sort of the idea that certitude was dangerous almost, and that it is part of our responsibility to understand the limitations of our own knowledge, to learn, to update, and I don't know when, at some point I hope you'll share a clip of his Harvard speech. But part of what that Harvard speech was about is just about the danger of certitude. And I think we're in a moment right now of anxiety. I mean, a global moment, not just in the United States, of anxiety and fear and a desire to kind of have control. And you see that in many different countries. And it tends to a sort of political, psychological, tend towards authoritarianism, tend towards the sense of just wanting things to be clear. And he he pushed back against that in every way and was comfortable with his discomfort in uncertainty. That's a very, I think, brave place to be. And it is uncomfortable, but I think it's very human.
So, Erin, you asked for the Harvard commencement address. You will get the Harvard commencement address. So he delivered that address in 2010, and he offered a portrait of his fact-intensive, values-based approach to constitutional interpretation. He also offered some criticisms of overly rigid interpretive methods, such as textualism and originalism. And we would like our listeners to be able to hear a little bit of it, because it does seem to capture the way he approached his role as a Supreme Court justice. So here are some clips.
The Constitution has to be read as a whole, and when it is, other values crop up in potential conflict with unfettered rights to publish. The value of security for the nation and the value of the president's authority in matters foreign and military. The explicit terms of the Constitution, in other words, can create a conflict of approved values, and the explicit terms of the Constitution do not resolve that conflict when it arises. A choice may have to be made, not because language is vague, but because the Constitution embodies the desire of the American people, like most people, to have things both ways. We want order and security, and we also want liberty. And we want not only liberty, but equality as well. And these pairs of desires of ours can clash, and when they do, a court is forced to choose between them, between one constitutional good thing and another one. The court has to decide which of our approved desires has the better claim, right here, right now, and a court has to do a lot more than read fairly when it makes this kind of choice.
So that opening reference, I think, is to the Pentagon Papers case. And I guess either or both of you, would you like to reflect at all on those remarks?
What I remember from that speech, and I don't even think we heard this phrase, but he said that there's just a natural longing for a world without ambiguity. And I see that in my classroom all the time. Like it's like a comfort in security, like knowing the answer for sure. But that's a false comfort. And Justice Souter, I think, bravely stood up for that principle in a way that is much harder to do now. It's like I actually get emotional hearing him talk about it, because it seems so different from the world we're living in right now.
When I interviewed, he read my student note, which was very kind of theoretical, and he's very pragmatic, and so he kept talking about well, what does this mean pragmatically, and went on, and what's so funny about that and his pragmatism, but what is true is, I think, although I haven't done a count recently, but I think he may have the most law professors of any justice. And what is interesting, even though his desire was for this kind of go out and be a pragmatic lawyer, so many of his clerks ended up becoming law professors. And here I'm just going to put in a plug for the university, which I think is under some attack today, that it is where we do search for truth, and where we have to be uncomfortable with uncertainty, and where we are meant to challenge received wisdom. And it is, I think, to his credit that there are so many of us who participate in that project of uncertainty, of learning, of self-reflection, challenging, and of challenging, as Ali said, our students to realize that things are not easy, and that when we search for the easy, we may be doing ourselves a disservice, not just us, but society a disservice.
Yeah, and I want to add one thing that clip, and as Ali said, he's got lots of other wonderful material in that speech. It's very much worth listening to or reading in its entirety. But one thing that I thought about listening to the part we just played is that just this kind of openness about the inherently value-laden nature of judging, especially in constitutional cases. And you're both talking about kind of certain contrast between that vision and the present moment. Like, I am just reminded of the kind of contrast between that kind of openness and candor with the kind of current Supreme Court majority's insistence that it is not doing that. Like, I think about the immunity decision from last year. The court is just like, it is the court taking the position that it thinks the value of shielding the president from legal process and shielding, its vision of presidential decision making from like potential chilling is more important than other values, than like accountability, than congressional authority to pass, statutes criminalizing certain conduct. Like, that's just a normative judgment, inescapably. But the court is never honest about what it is doing in those cases. And I just read Souter as basically admitting and inviting others to kind of admit that that is just part of judging. And there's something deeply anti-democratic because it evades accountability when judges don't actually take responsibility for that aspect of judging. Maybe that's all a little kind of general. I wonder if either of you has specific cases that you could point to where his jurisprudence, his interpretive methodology, his personal values, kind of any or all, were sort of in particular on display. Allie, do you want to name any cases?
Sure. Well, I clerked the year that the Hamdan case was decided, which was one of the Guantanamo Bay cases. But there was a very Souter-specific moment in that term, because during the oral argument, he was uncharacteristically, like, I think he actually rose from the bench. Like, he wagged his finger and rose from the bench at the possible implication that Congress could accidentally suspend the writ of habeas corpus. And I remember him saying, what? Like, the writ is the writ. And just in a way that a tone of voice that was uncharacteristic for him. And I think that showed that even though he was a judicial conservative and didn't like to make waves, he also he knew that there was importance in standing up, and that there was a judicial responsibility in safeguarding freedom and liberty. And that was an example of him, where the line had been crossed for him.
How about you, Erin?
The case I was thinking of is District Attorney's Office versus Osborne, in which Justice Souter dissented, and it was about access to state-held DNA for post-conviction testing. And he concluded that there was enough, there was a right within the state scheme in order to do this, but he wanted to say something about a substantive due process claim that had been made and that he thought should not be decided yet, but wanted to say some things about substantive due process in his dissent. And so he asked me to look for what he understood to be the court's approach to substantive due process. And he said, well, we don't rush it, and timing matters, and surely we've said this somewhere. And so I was looking, and I said, well, Justice, no one has actually said this. I believe this is exactly what happens, where there's a question about timing and where things stand. But we couldn't find an explicit statement. And so he made one. And this is, Kate, I think your point about candor, was that he said, listen, and you see resonances of what he did in the Harvard speech. He said, we need to take into account that society changes. There's changes in societal understanding. Society is going to work through issues. And he wrote this all out as a way of trying to make sense of substantive due process, taking that tradition was, of course, a serious consideration, but that it could not be all, and that you had to understand that, and his quotes, yesterday's reasonable range of the government's options could turn into today's due process anomaly or ultimately violation. And this sense of learning and changing, and that it was part of the court's responsibility to take this into account, was something that he was not afraid of acknowledging. I mean, everyone knows the Casey decision, the 3-judge plurality decision, where there's just an acknowledgement in candid terms of what exactly is happening as a Supreme Court in a constitutional system like our own. And again, he just wasn't afraid of trying to explain that.
So, Erin, since you mentioned Planned Parenthood versus Casey, this is maybe one of his most famous moments during his tenure. In that case, he joined the 3-justice plurality together with Justices O'Connor and Kennedy to uphold the central holding of Roe versus Wade and declining to overrule the decision. So I guess I am curious to hear what you think about how or if that decision is representative of the justice's broader jurisprudence.
I think it is. I mean, so the part of that plurality that he's most associated with is the stare decisis discussion. And I think the way he approached precedent and stare decisis was very emblematic of who he was and his respect for those judges that came before him. So it wasn't just, I don't want to rock the boat, although there was a little bit of that. But I think it was, we need to really look into, I'm not the first to think about this. I'm not the first to encounter this. And so I should give, if not deference, at least significant respect to the views of those who came before me. And that's why he's well known for having such a friendship with Justice Brennan when Justice Brennan was a senior justice. And, he respected judges, not just of his own time, but those that came before him. So I do think it's an example of a larger approach to the law.
Can I just mention, since we're talking about favorite Souter opinions or, kind of emblematic or representative ones, I'm not sure that it's as well known as it should be, but one of my favorite of his opinions was his dissent in the Crawford versus Marion County voter ID case. That was from the term that I clerked. And the court, regrettably, in my view, although the opinion was written by the justice for whom I clerked, Justice Stevens, upheld that it was the first encounter the Supreme Court had with the voter ID law. And Justice Souter just writes a really powerful dissent that, the court has some cases that reflect this kind of, balance of values that we've already been talking about him engaging in kind of generally. So these Anderson and Burdick cases say, we ask about how big the burden on the right to vote is, and we ask about how important the state interest is. And he's just kind of very pragmatic in doing this weighing and just basically says tens of thousands of voting age people in Indiana don't have necessary photo ID. I'm going to quote a sentence, a large proportion of them are likely to be in bad shape economically, right? It's not a very technical assessment, but it's clearly right. And he says the state's asserted interest in modernizing elections and combating fraud are decidedly modest. At best, they fail to offset the clear inference that thousands of Indiana citizens will be discouraged from voting. So it's just a very practical, we've got these values at stake. We have to look at facts and sort of decide how they shake out. And again, it's sort of inescapably normative. So, okay, we wanted to play maybe one or two clips of Justice Souter asking questions during oral arguments. He had a reputation for being a pretty incisive questioner, although, invariably very polite during oral arguments. And one example I like a lot is during the arguments in United States versus Lopez, the case about whether, Congress exceeded its Commerce Clause authority when it enacted the Gun-Free School Zones Act. First-year law students are very familiar with the case. So in his questioning, Souter was, it seemed to be concerned about the kind of expanding scope of, legislative power and sort of the lack of limits that Congress had observed. And he drew some laughs during this clip. And I also have to say I want to play it because when he's first on the bench, you hear the New Hampshire in his voice way louder than in the Harvard speech, which is much more recent. So for our listeners, both the substance and just the kind of vocal quality, wanted to play this clip.
I mean, that is no limit. Benjamin Franklin said it is so wonderful to be a rational animal that there is a reason for everything that one does. And if that's the test, it's all over.
Okay, so he sounds kind of skeptical about the rational basis test being insufficiently demanding, although, ultimately he does dissent from the court's decision that Congress had exceeded its authority in enacting that law. Okay, so maybe just one more, since Ali already brought up the Hamdan oral argument. So, I'm not sure if this is the moment when he rose from the bench, but he's definitely really, concerned about, undermining the great writ. So let's play that clip from Hamdan here.
The whole point, it seems to me, of the argument is, should we not consider the significance of those very questions? Because if we don't, as Justice Breyer said, at the end of the day, as you describe it, we will have to face the serious constitutional question whether Congress can, in fact, limit jurisdiction without suspending habeas corpus. The whole point is to grapple with them now and to treat them in a way that allows for this adjudication so that we avoid this constitutional difficulty tomorrow.
Okay, so much ink has been spilled over the fact that Justice Souter was appointed by a Republican president, George H.W. Bush, but over time evolved to become a reliable member of the court's more liberal, progressive bloc. Today, the phrase "no more Souters," became a rallying cry for Republicans who wanted to appoint and want to appoint only those whose votes they feel confident they can predict in some set of important cases.
I will just say that I know that my old boss, Justice Stevens, who was also a Republican appointee who became in many ways the leader of the court's liberal bloc, would insist that he had not changed, but the court had, and maybe the country had changed around him. And, whatever you make of that answer, I'm curious how you think Justice Souter would have responded to questions about his ideological shift. Allie, what do you think?
I think he thought of himself as a conservative, and I think if you look at his confirmation hearing, he's remarkably candid about the way he thinks of the right to privacy, for example. The idea that it was some sort of stealth, move to the, that's just false. And I do think, as I said before, I think he was a conservative. I think that what it means to be a conservative has changed.
Erin, what do you think?
I completely agree. And also, being from New England, I'm in a New England shed at the moment, as I said, trying to be Soutarian.
Perfect location, yeah.
Exactly. That kind of small c conservatism is very New England, and the way in which his, kind of maybe a little bit libertarian aspect on some of it dovetailed isn't surprising given his background. And I'm not sure, I wonder how surprising it was to President Bush, or if President Bush knew what he was getting in that selection of Justice Souter. There's a certain kind of New England, New Hampshire background that seems similar to me. And perhaps the country did change around him.
I like that he, in some ways, I think, better acknowledged that the court and the country had changed around him than some other justices have. When we did, for example, our retrospective on Justice O'Connor, one of her former law clerks kind of talked about how she might not have recognized the ways in which the Republican Party had changed around her. Whereas it seems like Justice Souter kind of understood what he was about and his core, and could recognize, when law, life, court, country, society, might not be, I guess, for lack of a better phrase, channeling the same vibe. So I guess, we're getting to the end of this, but what might we all learn from Justice Souter's approach to life and law, whether it's his lifestyle or his legal reasoning or, any aspect of the justice that you knew?
It's interesting to reflect upon this in some ways, because he wasn't someone that talked about or probably even thought a lot about his own legacy. But for me, the legacy is what I wrote about in that tribute, really thinking about the law's impact on humanity and the human connection. And he did his job with that at the forefront of his mind. Not trying to make waves, not trying to make sound bites, but trying to responsibly carry out the important power that had been placed upon him. So I think that is what I would take as an important part of his legacy.
On a personal level, I think I would add to that, which I of course agree, Allie, I would add that he knew himself and he was comfortable with himself, and he wasn't trying to be anything other than himself, except when people mistook him for Justice Breyer, which he thought was hilarious. He was from New Hampshire. He went back to New Hampshire. He climbed the mountains of New Hampshire. He was, I think, the last Supreme Court justice who was a state court justice. There was a certain primacy of place in his heart. He was comfortable with who he was, and he talked about this quite a bit in his last year. He was ready to retire because he did not want the court to be all who he was. He did not want that to be it. He was a person with many other interests, with other things he wanted to explore, and the idea that he would just be synonymous with this one part of a long, varied, and engaged life was distressing to him. And I think he probably would have thought it distressing to the country. It's interesting to me that he retired at 19 years. And as anyone who's read the Biden Commission will know, we're the only country in the world with no retirement age and no term limit. It's an unusual situation from a comparative perspective. And 20 years is often a time that seems accurate for service. And so, but it wasn't just about the court, it was about himself. It was about what he wanted. And I think that's something to remember. And again, another impressive aspect of him as a person.
I hadn't thought about that 19 years here. Yeah, because the proposals that sort of are afoot for limiting the terms of Supreme Court justices here tend to be in like the 18-year range. So maybe like the yes, more suitors rallying cry
yes, more
could be
suitors.
Reappropriated for a term limit push. And also just briefly, like Erin mentioned the Justice Breyer confusion. So for listeners who aren't familiar with this, like I might garble this story, so correct me if I get any of it wrong, but there's like this famous Souter anecdote in which he's stopping at a gas station in New Hampshire or something, and somebody says, "Oh my God, it's Steve Breyer." And then he does sort of plays along, and then, doesn't want to like embarrass the guy by correcting him. But then when the person asks him what the best thing about serving on the Supreme Court is, he says somewhat cheekily like, "Oh, the opportunity to work with David Souter." Did I get that basically right?
Exactly.
So it's sort of like his humility, but like his sort of wry sense of humor. Like I can sort of see him. The term I clerked, he and Justice Stevens were very close. So we got to spend probably more time with him than any other justice apart from our own. And so I can sort of envision him saying that. If either of you have any sort of thoughts that, I think it's right, he probably didn't think about legacy much, but things that Justice would have wanted to like leave as his parting lesson to the next generation of lawyers and citizens.
I think what we said earlier about being comfortable with ambiguity and rejecting the search for certainty, and that's also, by the way, reflective of that humanity that he embraced. Like that's who we are. And I think even though he would have rejected the idea of wanting to leave a legacy, to me, I think he would have been proud if that's what people remember.
He famously did not love the Supreme Court in Washington and everything, but I think he appreciated the opportunity to do his job. He called the Constitution a pantheon of values. I mean, he was, I think, deeply faithful to the concept of all that the United States could be and would want that to be remembered as well. He said in that Harvard speech, hard cases are hard because the Constitution doesn't give a simple rule of decision, but there's a lot of good things in that document. He didn't say that last part. That's my paraphrase. But that there are a lot of good values, and the fact that you have to make hard choices is part of the judge's job, but it doesn't in any way denigrate the idea that it is in fact a pantheon of values.